It's a pleasure to see you all here today. My name is Louveaux. I'm the Global Chief Privacy Officer at Mastercard. So let me set the scene here. Identity is really what makes our existence in this world official, right? And it's the foundation for us to participate in the economy. And as we live more and more online, well, we need access to a lot of digital services, healthcare, education, payments, and you name it. Now, in this online world, we need to be able to prove that we are who we say we are. And we need to be able to prove that we are entitled to all those services. And let's be honest, passwords, security questions, they are really methods of the past, right? It's no longer safe and secure. All that data has been compromised or will be compromised at some point and available to fraudsters. So it's time to innovate in this space. And over the last couple of years, we've seen the emergence of electronic identification schemes, so eID schemes, that allow individuals to manage and authenticate their identities when they use online public services. So we have a good example here in Belgium with the Belgian eID. We have examples in the Netherlands, in Germany, and more countries. And so all those national schemes have actually been encouraged by the adoption of the regulation on electronic identification and trust services in the internal market. And so, in short, the eIDAS regulation. And that regulation really provides a ground for interoperability between those schemes to really enable secure electronic transactions, right? And that should facilitate data protection by design. So what is data protection by design? As you all know, this is really, it means that privacy and data protection have to be embedded in the design of products, services, technologies, from the very early stage of the product development process throughout the product lifecycle. And so the question is, how does that apply in practice in the context of digital identity? Well, that's a good question, and that's exactly what we will explore today. But before getting there, you may ask yourself, what is Mastercard doing here on stage? Well, believe it or not, Mastercard is highly interested in digital identity. And we believe in a decentralized digital identity model, where the data would sit with the individual. So with you, it would be stored, for example, on your device. Or the data would sit with a trusted source to whom you have already provided your data. For example, your bank, your mobile operator, your government. And in no instance would the data be stored in a centralized database, because that would open really a lot of security risks. And we believe that you should have full control over the use, the collection, and the disclosure of your identity data. And so we are in the process of developing a new digital identity service where we would not collect any data, but we would just enable the validation of the data that resides with those trusted sources. More to come on that front. So let me now introduce a fantastic panel. So let me get started with Sophie. Sophie Stalla-Bourdillon on my left. Sophie's a professor in information technology law and data governance within the Southampton Law School. She's also a senior privacy counsel and legal engineer at EEMA. Sophie is director of the Web Science Institute and a member of the Southampton Cybersecurity Center of Excellence. Sophie is involved in many different research projects, and currently she's working on a project on anonymization and also on the implication of the data protection by design approach for electronic identification for the Horizon 2020 FutureTrust research project on this topic. So the list is long about Sophie's achievements, but let me just say one more word. Sophie is a creator of Peep Beep, which is a blog dedicated to privacy and information law. And Sophie will be your moderator today, so watch out. You may be quoted in her blog, but don't worry, everything is going to be anonymized. So on Sophie's left, we have Marc. Marc is working for PricewaterhouseCoopers Advisory Services in Belgium. He specialized in ICT security and performance. And he's specialized actually in the security field, both from a technical perspective, but also from an organizational and management perspective. And Marc is very much involved in authorizations and access control, biometric recognition, smart cards, and you name it. On Marc's left, We have Marc King. Marc spent 30 years at the GCHQ, and he has been very much involved in international security standards. He has a passion for integrity policy and international interoperability. And I think he left public service to dedicate himself to digital identity. In 2010, he's like an Australian. He has a chip on both shoulders. He may tell you more about it. On Marc's left, we have Niko. Niko Tsakalakis.
Yep.
Good, I practiced. Niko is a senior research assistant for the H2020 project FutureTrust, Services for Trustworthy Global Transactions. He has a PhD, he's a PhD candidate in the Web Science Institute at the University of Southampton. His research focuses on privacy and data protection for electronic identification schemes. And his current work with FutureTrust aims at supporting the practical implementation of the eIDAS regulation. And last but not least, Eric Verheul. He's part-time professor at the Radboud University, Nijmegen. I'm not quite sure how to pronounce it.
Nijmegen, yeah.
Okay, thanks. In the Netherlands. He teaches security management and does research in cryptography, focusing on privacy-enhancing technology and pseudonymization. And Eric is also a consultant, and in that role, he's cryptographic architect of the Dutch federative eID scheme. And so we're looking forward to hear more about this. On that note, Sophie, the floor is yours.
So, thank you so much, Caroline. I just say a quick few words to introduce the questions that the panel is going to answer, and then I'll give the floor to Niko, Marc Biss, and Eric. As Caroline said, the reason for having this panel is essentially eIDAS. Yeah? That's the short name. The long name is the Regulation on Electronic Identification and Trust Services for Electronic Transactions in the Internal Market. Okay? It's a bit less known than the GDPR, but it's still a very important piece of legislation at the EU level, which makes the EU a leader in the field of digital identity and identification. The building blocks of eIDAS are mutual recognition of eID schemes, and importantly, a framework that makes it possible for national schemes to talk to each other. Yeah? eIDAS ambition, it is intended to be technologically neutral and to facilitate privacy by design. And in that sense, it's possible to say that eIDAS was the big sister and GDPR the small brother. That being said, as you see, it only says facilitate privacy by design, yeah? Which in the GDPR you find data protection by design. So another limitation of eIDAS, eIDAS is meant to promote access to government services. So it is intended to solve only one problem, which is eGovernment only. And one of the questions that is on the table is whether we should extend the framework to make it work also with private sector services. The questions for the panel are the following. What does it mean to do data protection by design for eID schemes, as Caroline noted? How does the EU framework impact upon national eID schemes in terms of data protection by design? And what would be the consequences if eIDAS was extended to private sector services? So that's the background. With this, we will start with Niko, who is going to give you a taste of what is in eIDAS and the implications, the impact of the framework on national schemes.
Thank you. Right, can everybody hear me? Yeah. Good morning. I'm Niko. I work with FutureTrust, which is a Horizons 2020 project. It aims to materialize eIDAS by providing easy and scalable eID and trust service solutions. You can find more about it if you go to futuretrust.eu. What I will be talking about today is, and hopefully give an aspect of an answer to all the three questions you just saw, I'm going to start by defining the eIDAS ecosystem. We're talking about eID services, so services that provide authentication and identification to online public services. This is the eIDAS material scope. eIDAS doesn't regulate the eID schemes themselves. What it does is create an interoperability framework so that these schemes can, let's say, talk to each other. This happens through eIDAS nodes, which translates from one scheme to the other. In order to do that and to accommodate the different architectures that national schemes have, eIDAS defines a minimum data set. It's a common denominator of attributes that will be sent for eID transactions, and it contains mandatory parts and an optional part. Now, because the minimum data set is obviously personal data, eIDAS mandates that all processing will happen according to the then Data Protection Directive, which of course has since been superseded by the GDPR. I trust many of you will be familiar with Article 25 that introduces data protection by design in the GDPR, but let me break it down nevertheless. Data protection by design has two goals: implement data protection principles and integrate necessary safeguard into the processing. The way to do that is through appropriate technology and appropriate organization. The GDPR gives us two examples of that: data minimization and pseudonymization. But the appropriateness of the measures has to be contextual. So it depends, it has to be proportionate to the nature, scope, context, and purposes of processing, the state of the art, the cost of implementation, and the risks posed to the data subjects. Now, let me explain why I think data minimization and pseudonymization is important for eIDs. If we take the example of the minimum data set, and you can't say that eIDAS was expecting the GDPR in some extent because it provides for some form of data minimization through the minimum data set. It also provides for some form of pseudonymization through its Article 5, where it states that pseudonyms shall not be prohibited from being used, and Article 12, which is what Sophie referred to about facilitating privacy by design. So let's take the minimum data set, which you can see on your left-hand side, I'm going to say. Yep. So full data minimization, or extreme data minimization, if you want to say, would enable for selected attributes to be transmitted every time according to the needs of the service provider. So service providers that only need to know your date of birth would only get that. That's a process that we call selective disclosure. Substituting the values of some attributes with pseudonyms, so essentially pseudonymization, would allow to minimize linking that can happen across users so that service providers or identity providers cannot profile where you're using your eID. And there are several schemes in Europe at the moment that offer these kind of services. Now, this is where the interoperability framework, in my opinion, might be slightly problematic. That's because of the existence of the minimum data set, because at least the mandatory part of it has to be transmitted. There's no real selective disclosure available. And even if we substitute the unique identifier of the minimum data set with the pseudonym, because the identifier has to be as persistent as possible in time, that pseudonym will work as a de facto identifier in the end. This is important because even if we, the premise is that public services are going to need all these attributes to successfully match somebody. Even if that's true, even though I would argue that there are public services that don't need all of them, the Commission is hoping, and you can see that in their communication about online platforms, is hoping that the private sector at some point is going to want to use eIDAS to offer authentication to users. If and when that happens, the existence of the minimum data set would practically mean that national eID schemes that can offer more advanced data protection by design, so selective disclosure and minimization, will have to lower the level of data protection by design they can offer when participating in the eIDAS. Now, is there a solution to this? I would propose that we can perhaps embed selective disclosure and pseudonymization in the eIDAS nodes. So with no need to alter the actual eIDAS regulation, if we can embed selective disclosure in the eIDAS node of either the transmitting scheme or the receiving scheme, then national schemes that do support them will be able to take advantage of them. I don't know if it's practical to do it in the transmitting scheme, but it is definitely feasible in the receiving scheme, and maybe further along the panel you're going to hear opinions on that. But if we do that, that means that we avoid the risk of all the service providers in one member state receiving the same amount of data and therefore being able to correlate that data to profile you. And with that, I'm going to leave you.
Thank you so much, Niko. So if I sum up, does the interoperability framework facilitate privacy by design?
I would say it facilitates a level of privacy by design. It's not necessarily the state of the art. It's not necessarily on par with what many eIDAS schemes in Europe can offer at the moment.
And is there a way to fix it? The answer should be
yes.
Thank you so much. Marc is going to give you a taste of what's happening in Belgium and how should we be thinking about data protection by design in that context.
Good morning. I thought I'll run you through these points at a reasonably high speed. So the GDPR Article 25 expectations, they've already been, I think, quite well explained. I'll say a bit more about eIDAS and then something about the way forward, not necessarily only in Belgium, also a bit abroad. Article 25, you need to have these technical and organizational measures should be by default, and pseudonymization is a good way. Now, if you look at the implementation of eIDAS, you have this reference implementation of what's called the eIDAS nodes. And if you have a scenario like on the left, you have a person of the member state B, which is the member state on the right, is visiting a service provider in another member state, in member state A. Well, then he will use the service provider where he wants to authenticate if the citizen of member state B has an EID and notified EID. The service provider will link to the connector will link to the proxy of the ECHR, who will go to the IDP, and there will be a token flowing back saying, okay, we as IDP on the right, we guarantee to the service provider on the utmost left that this citizen is indeed this citizen. And what is then there being passed along? That's what Niko already referred to. That's the minimum data set. And this minimum data set is, the current family name, last name, first name, date of birth, and then some unique identifier. And that's where the crux is, because this unique identifier in practice, like in Belgium, it is containing your date of birth and your gender. So it is the opposite of what you could imagine as a pseudonym or a random number. And actually, I was, I think almost 20 years ago, I was in the team that set up the Belgian EID. And we had a very strong argument with the Director General of the National Register, because we said, this is very stupid design from a privacy point of view. And we think this is the time to change it. And he said, well, we are not going to do it because this is going to break the majority of our applications. They use that information which is in this number. And maybe you don't like the design, but that's how it's going to be, and that's how we're going to implement it. So now get out of my office. So that was, let's say, a test for reality. Now, I've been involved in quite a bit of the eIDAS work for DG Connect, for the Commission, and you could say that there are, in fact, two tendencies. One tendency is the Commission would like that eIDAS is used more broadly, also in like financial services for KYC and AML. And then there is, of course, an interest by the financial institutions to have more data in the minimum data set. And some voices in Connect seem to be receptive to that. On the other hand, there is a tendency to have more privacy. So have maybe not even a minimum data set, or just have a set of protocols to do selective disclosure. And we will see where, well, which way the Commission is going to take. I don't have a crystal ball, unfortunately. So the main requirements you would have in these type of schemes are anonymity. So if you're alone, you can never be anonymous. Anonymity is typically linked to crowds. Then you have the usage of a pseudonym, which can be once, or you can every time receive a new pseudonym. Then you have the unlinkability and the unobservability of some communication or authentication or whatever. And there are many schemes in the world that are based on this public key cryptography, and they can encrypt stuff and they can do strong authentication, and it's feasible to have reasonable privacy, but it's very hard. But on the other end, the people working on the math side of things, they have anonymous credentials, protocols for selective disclosure, verifiable encryption, homomorphic solutions, which are all, they used to be probably quite exotic 10 years ago, but today I'm very happy to have Erik here on the panel who will explain what he designed and what the Dutch government is actually implementing as a homomorphic encryption scheme for privacy by design. I think that's probably across the world, I think that's probably the leading edge in government. How compatible is it with eIDAS? Well, I think it is indeed compatible, but we will see how it will integrate with all the other ID schemes of the other member states. Then there is another an interesting tendency. Out of this blockchain universe came one of the project that's called the Sovereign project, and they have something called self-sovereign identity, which is very much like what I heard our chair, Caroline Louveaux, mention, like a decentralized. Now, if you make an identity self-sovereign, the first question that comes to mind is, can I then declare that I am Angela May or something? Well, the point in all of these schemes is that there is some kind of bootstrap where you would rely on the government. You could then enrich your baseline identity with a whole series of attributes, and you are the sole manager of these attributes, which sounds like quite an interesting scheme, particularly because there are now so many, let's say, mathematical techniques of selective disclosure and zero knowledge proofs that you could actually indeed build such a solution. And this is being built, this is being experimented with. It's quite nice. There is going to be a European one, which is called ESSIF, the European Self-Sovereign Identity Framework, and we'll see how far they get with that. That's the EBP, is the European Blockchain Platform, which is created by a treaties among the member states, where they say we're going to develop a blockchain infrastructure across Europe. It's going to be funded through the Connecting Europe facility as from March this year. And one of the 10 projects that they want to be building is the European self-sovereign identity. And the last point I want to bring to the table is that the guy who gave us the World Wide Web, Tim Berners-Lee, he started a new project which is called SOLID, for Social Open Linked Identities, where the idea is also very much into give people a decentralized ID and let them manage the attributes. So if you would run an application and you would need identity, you would have to pull it out of the data pot of each individual rather than visiting a central identity. Now, Tim Berners-Lee is, I think, probably pretty much a genius. So if he comes with his ID, he now has a first version of working software. He has a spin-off of MIT who is building this. So it does look, I think, extremely interesting. Well, that's what I wanted to contribute.
Thank you so much, Marc, for this very rich presentation. Can I ask a quick question in relation to the Belgium implementation? Where does the flow come from? From the national implementation or from the EU interoperability framework, from your perspective?
Which flow?
In terms of the abstraction by design and the mention that the unique identifier was telling too much.
Not quite sure what you mean by flow still. The drive?
You introduced the Belgium eID scheme, yeah?
Yeah.
And if I'm right, according to you, it's not best practice in terms of data protection by design.
Okay, the Belgian eID scheme is essentially a database where there are enrollment processes and then an issuance for a smart card. The set of data attributes include one attribute, which is like the social security number, and that contains your date of birth and your gender. And that is something that they inherited from the National Register database, which was providing a unique identifier for social security and healthcare and all of these. And that's just a very historic,
Okay, so
very stupid decision.
Okay, a Belgian decision.
I think there are more countries who are actually having this problem.
That was not meant to imply this. Yes, but I was just to highlight where the bad practice can come from. So you can have problems at the EU level, as highlighted by Niko, but also, I mean, it doesn't mean that you can't have also bad practice coming from the national implementation as well.
Absolutely.
And in terms of self-sovereign identity schemes, does it make sense to have both these types of schemes and eID schemes as it is provided for in eIDAS?
If you ask me, yes, because there are so many different type of usages of identity. I mean, eIDAS and so on was essentially built to solve government problems, because government is using tax money to give benefits to citizens. And on the other side of the spectrum, you could say there's the private sector, and they all have their own business models and their own solutions. And when I look at the Belgian eID scheme and so on, it was in the beginning strongly criticized by the banks, but the project just rolled on and said, listen, we are doing this for healthcare, for social services, for a whole series of, for taxes, for tax returns. So we have our own purposes. And I've seen studies where they explained that they had an incredible return on investment.
Okay. Thank you so much. Now, next, a UK perspective. Please, Marc.
Thank you. Well, because we're rather short in time this morning, this is definitely a biased account of where the potholes are. I'm not trying to give you a balanced account of what's going on, just to highlight some of the interesting challenges. One of which is that in 2005, all this interoperability of ID was agreed in the Manchester Declaration. The UK were pushing it very hard, and all the countries in the then common market decided that they would get together and do this by 2010. Clearly, we failed spectacularly. But eIDAS is actually coming after the event. So privacy by design is a bit sort of getting the history in the wrong order, because the actual design of many of these things, or creation of them, happened earlier. So I'd like to just mention a few things about the UK background in terms of the philosophical position, the distinction between the public and private sector requirements, some of the things that the UK has done, and here the word disappointment is typically British understatement. Zombie-like behaviour would perhaps be closer. Some of the things that eIDAS challenges as it stands, and also the possible ways of getting out of some of the worst cases. My first point is that many of us who predate all this stuff, because when I left university there was no privacy in law, there was no data protection. actually in law, just don't get rights. We're being told almost every week that we've got a new right, right to request. No, we haven't. We've got an obligation on somebody else to answer our requests, but to put it on the person as having suddenly a right to ask something, no, that's definitely philosophically the wrong way around looking at these things. There are also bizarre things for most people where things like naming is actually a highly emotive aspect for some religions, including some parts of Christianity. So ideas of pseudonymity and so forth, if people think that they really ought to be known by and use the name that was given to them by the priest or whoever, we can't ignore that in a grand international system. But the UK has some interesting features. Firstly, it is not for the job of the state to grant permission. It does various functions. We have no official name. We have no register of residence. There are a few things like lists for people voting, but there's no requirement to register when you change your house. There are plenty of pseudonyms in use, but they're things like Dr. Lawson, who's the same person as Mrs. King and not pretending to be. However, if she registers something in our London flat rather than our house in the country, then she's a completely different person according to the UK government verify system. There's something a bit funny about that. But also philosophically, there's a tremendous difference between the UK and the US in the language, and that is we are controlling the activities, not the people. So it is a driving license in the UK. You're controlling driving, and it's all about driving. And if you can't drive, you don't get a driving license that says you can't drive, you don't get a license. That's quite different from a driver's license. Anyway, in the public-private sector, which was one of the questions of where we're going here, ECHR, absolutely fundamental to this, and it talks about there being no interference in this right, qualified right, by a public authority. It says nothing at all about the private sector. So in some cultures, the sort of Anglo-Saxon one, that means they can do what they like. In others, the Saxon or perhaps Prussian one, no, you can't. But the laws are enforced by both public and private. The fraud is a concern of both public and private, and there are plenty of private organisations that are trying to put together systems for that. Are they allowed to interfere with the rights and, as defined in ECHR 8? It's not clear. Obligations are also costing. The ECHR obligations on subject access requests changed so that they were now not a token amount but free. That's a disaster for charities and for small organisations who can now have almost denial of service attack by people demanding information. There's not a problem for genuine customers. That's something that can be solved and has been much talked about. But for somebody who thought their grandfather used to be in the scout troop, it's a real problem. Also, one of the very good features of GDPR is that it emphasises that consent has to be genuine. And so it is essentially never for public sector obligations. Obviously, there are plenty of public sector applications, like having your health care, where it is indeed a matter of consent, but it is important that that's not. And unfortunately, one part of the UK system rather over-relies on consent. But I would emphasise that all of this, and this is the high moral ground of Europe, is it's about humans, not about citizens. Every time I hear something talking about citizens, I know it's a politician puff, because Human Rights Act is about humans. This is particularly interesting when we get to some of the eIDAS interoperability, because of course you can exist on the system in more than one country. UK government Verify started basically to be designed in 2010 when it was decided not to have an ID card. It had a number of privacy principles, which will be very familiar to privacy enthusiasts, but some of them are completely unreasonable and some are incompatible with others. So there also a bespoke section, which was not helpful for Whitehall to produce this without any consultation, other than to put them on the table with the minister approving them and say, we're having a consultation and the minister likes these. So the civil servants couldn't actually get into any sort of sensible discussion. There are tremendous constraints, which were political constraints on the way the system goes. For example, there is no public sector provision, as the Americans had envisaged. It all must be private. And it all must be done through the market, which when people aren't paying, doesn't really work according to normal market principles. It works on matching, not on a unique identifier. So you can have, well, probably easily about 14 different identifiers if you have 2 genuine names that you use and 7 providers from different companies. You can appear on this thing legitimately 14 times. And there is a presumption, which I heard yesterday again from the Commission, that somehow the choice and this is going to be helpful for trust from ordinary citizens. Microsoft very kindly pointed out that this was not the case, and they had 0% motivation for doing this. This is all about, in that case, the seal. It's about trustworthiness. And the UK system is level 2 on the scale of their own making, which has only got 1 point on it. So where it relates to the rest of the world is anybody's guess. eIDAS, as mentioned before, has a permanent sort of unique, somehow, number provided by the member state. Oh dear, that's not how it's done in the UK. Possibly to anyone, but in particular to non-resident non-citizens. And that is an intended feature of the Estonian eID card. So you don't have to be a resident, you don't have to be a citizen. And indeed, again, the UK card bears no relationship to citizenship. It's just somebody who's managed to get one. Minimum data set does not equal a matching data set. One is not a subset of the other. And so getting these to interoperate requires a certain amount of creative accounting. And in some countries, what we'll get is a consistent error message. I don't call that interoperability. There's a liability model for the private sector, which is not something which we yet understand. There is no system for repair, which was pointed out in 2008 was going to be essential, and it's not compatible with the international standards in this arena. But in particular, because of the limitations of European competence, this part of eID, not to the trust service section, but the identification section, is only applicable if all of the following apply. It is a cross-border transaction, a genuinely cross-border transaction. So if you're a Frenchman in Germany doing an action with the German government, that's not cross-border. It has to be a transaction with the public sector. How many of you ever deal with the public sector of another country? It is, interestingly and most bizarrely, only for authentication. Now, most of us thought this was for identification, in other words, logging in the first time. No, this is mandated only for coming back saying it's me again, which you should never be using your identification for. There are other methods of doing this, saying it's me again. It has to be at least substantial. What does substantial mean? Well, the politicians decided that substantial meant at least substantial. That has now been put together by the Commission. Unfortunately, it took them a year to get something which was rejected by the member states, but not by a sufficient majority, so they had to let it through. And then there's nothing mutual about mutual recognition. It's entirely one way. If the Germans say you have to recognize this, you have to recognize it if you've notified. Notification has to be done by a member state of the EU, but there is no limitation on the system, so the Maltese can easily notify a Russian system if they want to. It is genuinely ambiguous in all the versions that I've read as to whether it's required online or the online is required. So if you are, for example, able to use a paper version 2, then, oh dear, the foreigners can use a paper version 2. And it works through the whole of the year. I know of no example that actually satisfies all these requirements. Now, in some countries, it's true that eIDAS also is permissive, but in the UK, we don't need permissive. We can just do it anyway. So there are tremendous limitations on the application of it as it stands. Balance is an important part of what we're supposed to be doing here, and I think there is some hope that this will be able to be done using the World Bank much. I mean, they still have problems, but at least a lot more people are bought into the World Bank principles on that. And the chances are that actually, again, the payments industry will come to the rescue because payments are international, payments are done every day. And we need something to cope with children as well. So I just finished by suggesting that pseudonymity, like blockchain, has a place, but it has been proposed, overhyped, and now mandated by friends in high places as a panacea. It's very strange to find laws that say things like such as, okay? You know, why are you defining one of the options in the body of the law? At least it should be in the recital. Anyway, that's just some food for thought.
Thank you so much, Marc. So you depicted quite a, shall I say, pessimistic or, view of eID, in particular in the UK, but also at the EU level. So what should we do is verify, should we try to fix it? Or should we just give up?
No, the Majesty's Revenue and Customs are producing a system which is generally based on a single ID for that, and there is a real hope that that will work. Interestingly, that does already work with the German Ausweis, which has been notified and therefore is interoperable. But there are particularly, I mean, it's not just for the UK, but for the connection between the government and the private sector, we need to understand what the liability models are and how the payments are made. The Germans have very generously said that they're going to provide liability. They have to provide it free. I mean, this is the interesting dynamic of the eIDAS, that the notifying state, you've no idea how good their system is. There is some sort of peer review, but you generally, the relying parties can't know on what they're relying, but that doesn't matter because the notifying state takes the liability for the use. Now, that's just about acceptable for the public sector cross-border, although I'm not quite sure why my government is involved in my dealings with the French, should I ever have any. But in the private sector, it is not at all clear that it is appropriate use of taxpayers' money to provide liability cross-border for things that have got nothing to do with the state. So, but even if we have all that, there is no actual protocol, process, or definition of who's paying whom, what, for, and when. And until we've got some clarity on at least one proposed mechanism for that, I don't see how that's going to actually work.
Thank you so much. Now we'll pass the mic to Eric, hopefully giving us a slightly more optimistic view on the idea.
I hope so, yeah. I think so, but we'll see. So, okay, good morning. My name is Erik Verheul. I'm a part-time professor at the University of Nijmegen, the Radboud University. I teach security management and I do cryptographic research. Focusing on privacy enhancing technology. And I'm also an independent cryptographic consultant, and one of the projects I'm currently involved in is the Dutch EID scheme, for which I designed cryptographic design, which I'll briefly talk about today. I could talk all morning about this, so I only have 2 extra slides, so I will not talk about all of the details. There's a link on the page, and you can also find it on my homepage, that provides you with some of the cryptographic principles of the Dutch IDS scheme I designed. Already in 2014, by the way, so it's 4 years old now. Well, so far we have seen that a lot of countries are implementing strong authentication or two-factor authentication or whatever you want to call it. Primarily due to the eIDAS regulation. So what you typically see is that companies or organizations are implementing a federative EID scheme. Most countries have that. So it means that that you have actually placed the authentication part of the scheme at separate parties, at separate roles, IDPs, identity providers. And so if you want to authenticate to, let's say, a service provider, a medical service provider, as in the slide, then you actually are first redirected to identity provider that does the authentication using an app or a token or what have you, or a card. And then the actual result goes back to the service provider, and you're logged on to the scheme. So that's the basic idea, and that's what many countries are currently implementing. It's important to notice, and I don't think that everybody notices this good enough, strongly enough, is that finding a good balance in an EID scheme, federative EID scheme or not, but is to find a good balance between the three properties of security, privacy, and user-friendliness. And I can give you all kinds of examples of schemes that lack one of the three, and at the end of the day, you will not have a successful scheme. So if the scheme is not user-friendly enough, then the scheme will fail. If the scheme is not secure enough, then it will fail too. So there needs to be a balance, and you never can be perfect in all three of them. And what I see that my academic colleagues, when they talk about these things, I think they talk too much about privacy, and they somehow often forget about security. And that's important to notice, that security is in some cases more important than privacy. There needs to be a good balance between the three aspects. So one of the things, and that's actually related to a conflict between security and privacy, and that's also something that is not commonly known, I think, which surprises me, is that what you really want in an EID scheme is that you want to avoid that there is a privacy hotspot at the identity provider. So the idea is that if you have an identity provider in the scheme that I explained, then if you go to, let's say, to a medical healthcare provider, maybe a mental health care provider, then if you do it in a naive way, then the identity provider knows who you are because he provided you with an authentication mechanism, an app or whatever, and he also knows that you're visiting this healthcare provider, let's say this mental health care provider. So then there is a hotspot that the IDP knows who you are and knows that where you're going to, and that's considered to be a bad thing from a privacy perspective. So. So, for instance, if the IDP would be, let's say, a private organization like a bank, then you can imagine that if you log on through the bank every day at a mental health care provider, then you might have the idea that if you ask for an insurance, for a life insurance at the bank, maybe the bank will refuse you. At least that could be an idea that you could have. So you see that a lot of countries, including Belgium and the UK, have considered this issue. And they want to avoid a privacy hotspot. So what they actually do is they make the IDP blind. So what they actually do is that they introduce a hub in between the identity provider and the service provider, and the hub knows where you're going to. In this case, the service provider, the healthcare provider, and the identity provider doesn't know where you're going to. It only knows that you're going to the hub, but that's about it. And the hub and the identity provider does know who you are. So in the end of the day, the IDP knows who you are and he authenticates you, but he doesn't know where you're actually going to. That seems like a good idea from privacy, because you're avoiding a privacy hotspot at the IDP. But it's a bad idea from a security perspective, because it makes you susceptible to man-in-the-browser attacks. And man-in-the-browser attacks are attacks where you have malware in your browser, and that manipulates what you're actually seeing. So you actually think that you're authenticating to, let's say, your municipality or anything similar like that, some harmless site, while underwater, your malware is actually authenticating you to, let's say, your healthcare provider, and copies all your medical data and then blackmails you in paying ransomware, or otherwise your data will be revealed. So if you have a scheme where the identity provider is blind, then you win on security, but you lose on security. And I think you lose more on security than you win on privacy. But that's what I think. And actually, you could argue that if you have a blind IDP, it's conflicting with the GDPR itself. I think I'm not a legal person, but there needs to be consent. You need to give consent to the IDP for providing your information, but to who? He has no idea to who he's actually giving the information. So this at least seems to be conflicting with the consent part of the GDPR. So, but this is just an example of the conflict between security and privacy, so it's quite a complicated thing to have an optimal balance. So now let's talk about the Dutch EID scheme, and we have a solution where we actually get around the conflict, what I talked about between security and privacy. The actual scheme is also federative. It also allows a hub between the identity provider and the service provider. It's based on privacy by design from the start in 2014, and it's enforced by cryptography and more specifically by homomorphic encryption. Very basic homomorphic encryption, because one of the challenges is to have a scheme that's simple enough to be implementable in a simple way. That also relates to user-friendliness, but user-friendliness for the service providers. The scheme itself is technology neutral. So any technology, any eIDAS high or eIDAS substantial mechanism could hook up to this scheme. So it could be an app, it could be a token, it could be a card. That's all possible. It allows to authenticate users either under their social security number, the Dutch social security number, or under a pseudonym. And the actual pseudonym is based on the social security number, so that has all kinds of nice features. And actually, the pseudonyms have all the features and even more, I think, than you would typically expect. They are, I think, they are cryptographically very sound. So that's fine. And one of the ideas, one of the properties of the scheme is that although the IDP is able to provide you provide the social security number at the service provider, the identity provider doesn't need to know your social security number itself. So he can provide the social security number in an encrypted form to the service provider, but the identity provider doesn't get access to the social security number itself. So that's one of the features that we have in this scheme, and illustrating the privacy by design aspect. So I said the scheme is technology neutral. But there's one showpiece in the scheme, and that's the Dutch eID card. Actually, it's a Java card application that's either placed on a driver's license, on existing driver's license, which are electronic by nature in the Netherlands, or on the identity card. So it's the same application, but then on another type of card. These are issued since last year, so there are millions of them already. Provided to citizens, and this has particular nice security and privacy aspects. And let me mention one, and that's it allows for anonymous authentication, which seems like a paradox. So what actually happens is that if you want to use the card to authenticate, let's say, to the healthcare provider again, then you are redirected to the IDP. The identity provider, then there's an interaction with your card, and then at the end of the interaction, your social security number or your pseudonym is in encrypted form is sent through the authentication response to the service provider. So that's consistent with the whole scheme. But the point here is that during the interaction between the card and the identity provider, there is a randomization taking place. That means that the identity provider has no idea who you are. And even stronger, that if you would use the same scheme 1 second later, the identity provider would not even be able, at least cryptographic, to see that you were the same person. So what that means is that the identity provider anonymously authenticates you, but he's still able to see where you're going to. So he can actually warn you. He can actually say, "Are you sure you want to authenticate now to this healthcare provider?" So we actually have the conflict between security and privacy that I discussed in the previous slide. We have revealed, or we have solved this problem in this mechanism. And you could argue that in this way we have the best of security and privacy worlds implemented in the eIDAS card in the Netherlands. And as far as I know, there is no other eID scheme that has solved this problem in this way, while still facilitating both security and privacy in a proper way.
Thank you so much, Eric. So we should be all looking at what the Netherlands is doing, yeah, to see good practice. So how do you explain that this is not happening in other countries? Is it because they have started their scheme too early? Because we lack expertise?
It's very difficult for me to have a good idea about this. But what I see in practice is that if you talk to people that actually are able to solve these issues, then they tend to come with too complex solutions. And then the solutions are so complex that they are perfect, but they're not implementable in a good way. And then the governments, they need to go somewhere, and then they come and then they talk to less intelligent people who come with very simple solutions, and they are implementable. So I think that in some sense there is a problem with the academic community, that they're still in their and I'm also part of the academic community. So maybe I'm also talking to myself here, but they are in their ivory tower, and they are not really able to limit themselves to the real world, and that's one of the things that I try to do. And the scheme is not perfect, but I think it's good enough, and at least a lot better than the simple schemes that I've seen so far.
Okay, thank you. Before I give, before the floor can actually ask questions, I just want to go back to my chair to have her reaction as a representative of the private sector and the financial service. After having listened to these different talks, have you learned anything? Do you want to react? Do you want to?
Definitely, very interesting. I think actually, you know, there's even more room for us to enter the market. And I'm definitely gonna look at the Dutch solution, which is interesting. Honestly, I think it's a complex issue. I mean, right now we talk about actually public solutions. I know there are lots of companies in the private sector looking at this topic because there's definitely a need, and I fully agree. And that's actually my day-to-day job. That is actually a very hard thing to do to achieve the 3 parameters: so privacy, so best-in-class privacy, best-in-class security, and full user convenience. And it's actually really a risk-based approach there that needs to be struck. And I agree, actually, most of the people tend to actually focus on one or the other, but actually have to look at the 3 components and see the holistic picture.
Thank you so much, Caroline. Please, if you have any question, that's your turn now. Yeah, you can come to them or take the mic behind you. Yeah.
Thank you. My name is Lausinianis. I'm from the Moroccan DPA. I would like first to thank the panelists for their contribution and interesting presentations. I have actually 2 questions. The first one, do they think that the use of unique identifiers is a threat to privacy? And if it's not better to use like the matching solution that has been that is used in UK, this is the first one, instead of using one unique identifier. And second, do they know of any ID schemes that are based on biometric data? And if yes, what are the safeguards that are used in order to protect privacy of citizens? Thank you.
Thank you so much. Eric, do you want to start?
Well, I couldn't really understand the second question, but I can answer the second. I couldn't understand the first question, but I can answer the second question. So biometrics. So the eIDAS actually has 3 factors: possession, knowledge, and biometrics. And biometrics you can consider it in practical implementations, and there's no big issue there, as a PIN that is locally validated by either the trusted execution environment or the secure enclave in an iPhone, and that simply enables you to use a private key or something like that. So there is absolutely no reason why biometrics as a second factor could not be used throughout the eIDAS implementations. And in fact, if you look to banks, they already implement biometrics as a mechanism instead of a PIN. And it has all kinds of advantages, and I think that the current state of many platforms supporting biometric authentication, local biometric authentication, because you don't need to do that in you don't need to send the biometrics to an IDP or another third party, but local biometric authentication is good enough and is already used in practice.
Could I suggest that we do need to distinguish very clearly between identification, that's who you are when you're coming along for the first time to do something, and authentication, it's me again. The it's me again, biometrics is really useful for, and the private sector is what you can use it, can do that. Identification, the first time you're coming through, it's very, very useful for this to be somewhere in the background, a state unique identifier. That is the sort of underlying ground infrastructure without which you're then building on sand. You can then use that in a lot of privacy-friendly ways, as is done in the Netherlands, as is done in Austria, and is done by many banking systems in the Nordic countries. So having somewhere a unique identifier in the system is not in itself a bad thing. Using it blindly for everything is clearly foolish. So I think one can have both of these things, having some identifier used properly for identification. And at that stage, the biometrics really is not relevant because you're, other than for enrolling for other services, and then the authentication where various biometrics can be useful, and that's as they are today with passports.
Yeah, maybe in one experience, if the question is whether the use of a single unique identifier is a threat for privacy, well, I've been a couple of times in, let's say, within a bank, which I will not specify which one, but they showed me the data mining they do to identify wealthy individuals so they can target them for all types of financial services. When you ask them, are you sure this is legal? Well, no, it's probably not legal, but as long as we are not discovered and we are not fined, it's making a lot of money for the bank. And then, are you using things like a unique identifier, like the Belgian social security number? Yeah, of course, that's a great facilitator. Otherwise, it would be much more complicated to do the matching. To do the linking. Yeah, right. Thank you. So, yes, there is law, but on the other hand, it's only as strong as you enforce it, I guess.
Thank you. Another question, Charles.
My name is Charles Robb from the University of Edinburgh. Thank you to the panel. I wanted to address something particularly to Marc King, but also maybe a kind of slight corrective where you talked about the UK.
I probably meant England, didn't I?
Yeah, we in Scotland are always very sensitive about that, and particularly in this area where Scotland is now developing its own separate identity assurance system. What that's going to look like is not easy to say, but is probably going to be modeled in many respects upon Verify in terms of identity providers. And it leads me to ask a question about the transparency and the apparent choice that's being given to people to choose which identity provider they want to give them the first, their credentials. Because it seems to me that how, the question there is how is the individual to decide whether they want Experian or the post office or Barclays Bank and so on to be their identity provider. This is, my impression is that this is the illusion of choice when it is not clear what criteria the individual would use to decide between the one and the other. And I think there's some evidence, for example, that people overwhelmingly choose the post office because they don't understand what the post office is these days. The post office, people think that's the Queen, the Royal Mail. It isn't, it's a private company. In many ways, it's a kind of a front end of private providers and so forth. So I'm just wondering whether in the technical architecture of these things also includes a lot of interaction elements in which the individual may be at a disadvantage because of lack of knowledge about how to go about making these supposed choices. I wonder if you could comment on that.
Yes, well, certainly I was careful to mention Whitehall rather than that, but definitely the position in Scotland was very different, and there was a feel there of people thinking that this was something that was provided by the state and therefore they should use the state system. That then was found, the privacy folks really got very upset about that, and that was changed, as you know. So that's being rethought and being rethought with proper consultation. I'm expecting good things to come out of the experience of Scotland, who were kept out of the European discussions quite shamelessly. The Royal Mail is an interesting one because, of course, that's different from the Post Office, and the Royal Mail is actually pulled out of the system because they weren't getting any business. The business, as you say, was all going to the Post Office, who are the one providers who haven't actually been given the tick in the box. because the post office is actually just a white front for a Dutch company who's actually providing the service, who isn't getting much business directly, using exactly the same thing, and they have got the certificate of check. So it does look as though, and indeed people generally say that they trust the government. It may surprise people, but they trust the government with this information more than the private sector. And in particular, they think that the government, if they're doing it for government services, they don't want to divert via a private sector. The challenge really for the banks is that they could do all this perfectly well and sensibly, as they do in Canada, but the National Health Service in England has got a concern that they don't want any suggestion that your credit rating or your ability to pay is relevant for the service which is free at the point of use. I think actually if they brought it in through dentistry, that would have worked. But because people already pay for that. So it's a question of how you're using that system. So the payment system is something which is relevant there. But in terms of the user choice, I hope that Scotland will include a public sector option, and then people can have a genuine choice rather than a random choice amongst people that they have no way of actually choosing between.
Thank you so much. Another burning question before we close the session?
Maybe just a very quick question. Do you know whether the Dutch system will be notified?
When or if?
Or if yes, when?
I think yes, but I'm not sure when.
Okay.
But I think soon.
Mm-hmm. Maybe also just a quick general question, because eIDAS, it's focused on public services. Do you think there should also be some general regulation regarding private services, and would that anyway be possible?
eIDAS already mentions those, so it's already possible within eIDAS.
Yes, it facilitates them, but the limitations on European competence as to what they can do. The identification is something that the member states do. So it was not able to tell the states how to do this. All it could do was get involved in the interaction. And interestingly, the interaction only at substantial or high. So the lower levels are not affected at the moment by eIDAS.
And a big issue with that is that you have the same uniqueness identifier going to the public services in the other member states and for the private parties, because the minimal data set, including the uniqueness ID, is the same, which I think is a bad idea. You should at least have two of them to at least have this mechanism separated.
Mm-hmm. I do agree, but I was actually thinking about the different, for example, the Belgium It's Me, private authentication providers. So should they also be regulated in some way?
They are regulated because they need to go through the same assessments as the government identity
If they are
providers.
not providing for public services, but...
No, if they're not, then they can't be notified.
Yeah, indeed. No, I was wondering just outside of the eIDAS, since they don't fall under the eIDAS regulation. Should there be some kind of separate regulation if they provide...
Why not just use them?
Okay, no.
I mean, there's nothing, as far as I know, there is nothing stopping anybody in commerce using them
Indeed.
should they find them useful.
Indeed, no. Was just wondering about your opinion. That came up when I was talking about the other one, and thank you.
Thank you so much. We are now near to the end, and to close the panel, I go back to my chair.
Thank you, everyone. I think we had actually lots of interesting debate. I think it's not the last panel on this topic, definitely. Maybe actually one more thing that I wanted to say to wrap up, coming back to one of the questions, because we see more and more biometric authentication, and I know there's a lot. I mean, I can see and hear lots of questions about that. I think there's also a lot of misunderstanding as to how it works. So people are sometimes afraid of that and don't understand that. Right. So basically, very often what happens is that the biometrics, and actually that's what we propose as a solution, is actually encrypted and stored on the device. so that actually none of your biometric data would actually flow from one party to the other. So that's something that is often misunderstood, and I think because it's part of the identity authentication debate, I think it's worth mentioning. Thank you, everyone. Have a wonderful day.